from, they have a slightly different system in the UK, but it's similar to ours. And what happened was that they had to start getting a counselor involved. And he started apprising the widow of her rights and what her share would be. And at this point, it further complicated the matter. So what was initially would have been like, if the families had agreed on the first time, they could have had everything resolved. Now they had other people involved, like other counselors involved, and then attorneys involved, and the matter to this day is still not resolved. So this has been years going on. And that's the other thing we have to understand, is that we could have an intention in our heart, but if it's not manifested in paper, and if it's not manifested, the one other thing I also wanted to touch on was, with wills, when he was talking about formalities, he said 2 witnesses, but the witnesses have to be in the presence of the testator. The testator is who's actually drafting the will. He has to be in front of them, and the witnesses have to know that what they're signing and what they're witnessing is an actual will. So, for example, if I had drafted a will, and I wanted to use Siraj and Abdul Rahman to witness for me, and they don't know that they're signing my will, there could be an issue with that will being effective. For example, so say I just gave it to them, I say, hey, can you guys witness this for me? And it's just a piece of paper, it could be, you know,
the last page.
Last page, right, by itself, and I just tell them, oh, can you just sign this for me? They, not knowingly, could sign it, but that wouldn't be effective. And see, the thing is, in Florida and actually many other states, the idea for having these strict rules is to prevent fraud, to prevent duress. You know, you don't want it to be in a situation where, you know, you have a testator, you have someone who wants to do a will.
I have a question.
Sure.
Does the witness have to read the will?
No.
They just have to know what they're saying.
They have to know that, so they have to know that this is my will. So I take this here. I say, this is my will. This is my last will and testament. Will you witness this for me? And then he would sign it. And then secondary to that, what Abdul Rahman was saying, was that one, and then you get there's a second, it's like a declaration, and it's notarized. That substitutes for Abdul Rahman or Siraj have to come to court, just to come to court to say that we signed this knowing that this was his will, right? And that's the idea. It's because you don't want to have any of the...
witness died.
Yeah, the witness died, so say for example, Abdul Rahman, he moves. He decides to move out of Orlando, or Siraj moves out of Orlando, or I move somewhere in the state of Florida, and we lose contact. God forbid something happens. Now we have to trace back all these things.
And if you signed that paper, you wouldn't have to do that.
Right. And so that's the whole thing, is when you know, we're going to talk later about, you have these things, these self-help wills or these other forms that you can fill out. But sure, bro.
So the witness should know the contents of the will too?
No. Just to know that that you're signing, you're witnessing for a will. It's not that you need to know that, oh, I'm giving such and such to such and such person. No, sir. Just to know that, you know, this is my will.
What about Islamic way, like the Imam was saying that Gawah, like you should witness, you know, whenever you make a will, you should witness. So Gawah doesn't make, like you say something and the Gawah should know the contents of the will too.
But in the state, if it's not written, I don't think it's, if it's like that without it being written and following the rules that the state law lays out, that wouldn't be a valid law, basically.
Yeah. Yeah, so that's the challenge. The challenge becomes we have to put both the state law and the Islamic law and come up with something that is enforceable in the state. And that's the other problem. There's some people writing books and stuff, and they're selling these books, and they're from Texas or they're from Louisiana. And the system there is not the same as the system in Florida. So it would be like going to a doctor, and the doctor has not seen you, has not taken your history, does not know your family situation, and basically you call the doctor and say, I have an eye itch. The doctor writes you an antibiotic without seeing it. doesn't know, hasn't asked you if you have any allergies, hasn't asked you if you have a family history of so-and-so or so-and-so, and they just give you a will or a prescription. That's, unfortunately, in every situation is different.
That's malpractice.
It's malpractice for doctors, and it's malpractice for lawyers to sell these things and say that these are enforceable in the entire United States. So every situation is different, every family situation is different. A family that is all Muslim and all practicing is different than a family that is has converts in it, where you have to make sure that specific directions are put in the will as to what needs to happen after you're buried. It's different than if your family is all Muslim and all has always been Muslim, or if you're living somewhere else in the Middle East or where everyone practices, right? So every situation is different, and that's why it's important to get good advice. A person who has very little assets is different than a person who has a lot of assets. So that's why it could be, it's not something that I can tell you do this and it's going to work for everybody in here. There is certain things that work for everybody, but there's other people that have special situations. Just like I can use TurboTax, but some people can't use TurboTax. They have to go to an accountant, right? We're all doing our taxes now, right?
We'll get back on track with the
Yeah,
now.
yeah, so let's speed up, because I know I could talk about this all night because there's so many situations that we come across. But let me just move to what is the solution. The solution, if you have these named assets, is called a living trust. And a living trust is basically, the closest thing in Islam would be a waqf or an endowment or something, where you put someone, an ameen, a trustee, that is going to read the agreement that you give with that trustee, and that trustee is someone you trust to do this, and then you choose a few. If that person is not available, someone else. It could be the imam, it could be your brother, it could be your father, it could be anyone that you trust, because this trustee is going to have the power, the same as the court. This trustee will have all the power to effectuate your transfer without court supervision. Right? So it's very difficult for someone who is trusted, even if they're trusted, there's going to be a document. And if they don't follow the document, the beneficiaries can actually get that person in trouble. So
it's a contract.
It's a contract with that trustee, and there's liability for that trustee if they don't follow this letter of the contract. So basically, you write a contract. You're the person who is the grantor. You're the person who's writing it. You're the one that made that contract. Normally, in a living trust, you are also the initial trustee. So you appoint yourself as the trustee. So during your life, you put the ownership of the property in that trust. And during your life, since you're the trustee, you are the first beneficiary. You're allowed to do whatever you want with that property during your life. Once you pass away, the person you appointed as the successor trustee will automatically take your position and will now be able to dispose of the property the way you set out in the trust. These trusts are revocable, meaning if there's a change in the situation, you can change the trust. Okay? There's lots of changes that could happen. Someone may become non-Muslim in your family, and so you don't want them to take anymore. Someone may pass away. There's a lot of situations where you might want to change that trust. So these things should be updated. The person you had as a successor and his successor may both pass away, so you have to appoint a new successor. So these things are things that you should re-review every couple of years. Okay? So that's basically it. It substitutes for a will. It avoids the courts. No probate, no court, no $1 million to the lawyer. For us, that's we actually encourage it, because I don't see that taking that kind of money from an estate would be really halal money, unless it was really a very difficult case. I mean, taking a tenth of or 1% of an estate is
to basically manage it.
To basically do very little. It's not cool. So the other thing is, if you have minor children, children that are young, in the trust, you can have two separate, let's say you have a family member that is very good at taking care of children, is very bad at taking care of money, right? You can have that person who's very good at taking care of children be the guardian of the child, and the trustee be the trustee for the money. You have that flexibility with a trust.
And
Because
you really want to lay out for minors, this is top-rated parents with young children, you do these proactive steps to make sure your children are properly taken care of, financially and their tarbiyah, their upbringing.
Definitely.
So,
Yes.
I have a question.
Sure.
So the trust, that living trust, right?
Yes.
Do I have to name the people who will be the trustees? Or I can say, for example, there is this mosque, right? Its committee will be my trustee.
Yes. Yes. So it can be a corporate trustee.
Can you repeat the question?
Yeah, so the Imam, mashallah, he asked a very good question. The way non-Muslims do it, a lot of times they don't have anyone in their family that they trust, so they'll go to SunTrust. SunTrust has a trust division. And they'll say, we're going to appoint SunTrust as our corporate trustee. And they're going to oversee the trust. They're going to invest the money of the trust and have it generate income for the children, etc., etc. So that's a corporate trustee. Now, most Islamic societies are corporations, right? Non-profit corporations. You can have the Islamic society be the trustee of the trust. And we recommend that the mosque definitely be involved in certain aspects of the trust for sure. All right, ease of administration, again, with a guardianship proceeding or with a probate, you have to put an inventory in the court. You have to, and what is a court? When you file something with a court, what happens? It becomes public record. So everyone, maybe not everyone, but everyone with access to the court records, which is all lawyers,
Anyone, you go on the clerk website.
will know your family's net worth. Okay? They will know exactly what properties you left, how much they were worth, and how much each person got. Because that's going to be all public record. So, again, having a trust keeps it private, keeps it within the community, rather than having all this stuff as public. Okay? And reduce cost of administration. Really, if it's a family member, most family members just take their share and the costs of doing it. If it's a mosque, it depends on the mosque, but some mosques, if the person left a percentage to that mosque, that's fine. If the person left a donation to that mosque, and then obviously the mosque is a waqf for the community anyway. It's not in the business of doing things. I'm sure they would gladly do it for whatever the nasib is that the person wants, or no nasib, because it's a public service, right? However, you follow what your community leader tells you, inshallah. And then we talked about privacy and timing. Privacy and timing, with a trust, you can have everything taken care of before the burial. I mean, it's so quick because all you need is the death certificate and the trust. And at that point, the successor trustee takes immediate control. What happens if you don't have this, and this is, we don't have to go into details, but if you don't have a trustee and you don't have a trust and you pass away, and let's say you have a bank account with money in it, or a credit card that you normally pay off, but you passed away before you could pay it off. What happens? No one has access to that until the court appoints a personal representative who has to go through a whole process that will take a minimum of a month to 2 months. And then he takes that paperwork to the bank, and then they sometimes say, no, this isn't good enough. Go back and we need a red stamp, and it needs to be certified. No, go back, and you go back. And by the time you get there, you find that the bank took like interest upon interest and took all these fees, and the person had owed $2,000, now they owe $8,000. Right? With a trust, the trustee has immediate access to everything. Doesn't have to wait for the court approval. And the court system is very slow. Okay? Now I'm just going to really speed up, inshallah, and then we can talk case by case later. You guys can contact us, because again, like I said, we could go on till tomorrow. There's just so much information, and I know, because I teach the attention span of normal people, including me, 30 minutes to 45 minutes, then everything else is just me droning. So let's finish, inshallah.
What we can do, if there are any questions, is this an issue you guys want for us to touch upon, or do you want us to move to other things?
Yeah, let me look, what else do
We will have a question
Okay.
session, right?
Yeah, we'll have, yes. Okay, so I'm going to skip to a few things, because
in general, just so you know, a living revocable trust, because you still are in control of it, it doesn't serve as good protection for assets.
Yes.
That's the gist of it. So, because you're just creating a shell where you're still in control, so it doesn't have much asset protection if that's what your end goal is.
yes. So asset protection, meaning protection from creditors, trusts are not good for that, but there's other ways to incorporate trusts into corporations and LLCs. Oh, but this last part here is very, very important, and is actually one of the best things about a trust. Okay, we all have, let's not personalize. We all know of people that are not very good with money. They love to spend, right? Let's say it's one of your children. He loves to spend, and they overspent their money. If they overspent and you pass away, the trust can protect that person's share from their bad behavior, from their debts. Meaning that trust can hold their share for them until they need it, or just to take care of them, and not ever give them the money. They can put it in some sort of investment and only give them income for their health and support, only for certain things that you say. So I only want that person to have health, support, maintenance, and so no creditors can ever touch the actual principle of what you left them in that trust. So that's something that that's a protection that you can have for beneficiaries.
So even though he's 18, over 18?
Yep.
Yes, yes.
So I have a question.
Yeah.
If the spendthrift provision is in there, does it become irrevocable for the child?
It becomes irrevocable upon your death.
For the child?
For the child.
Correct.
Yes.
So it's a pass-through?
Yes. Yes. All right. So these are just case-by-case basis. This is what we take into account. Sometimes a child has special needs. Sometimes the beneficiary is too young. Sometimes the beneficiary, again, like I said, irresponsible, etc. Those are provisions that you can add into the trust to protect your family. Now we're going to move on to something even more important. This is something all of us should have, and I'm going to have a surgery, and they said, do you have one? And I think I did one, but I don't know where it went.
I won't charge him, I'll do it for free.
But honestly, like this right here, in Egypt they say something, there's a saying that says, "Bab al-Naggar mikhalla." The door of the carpenter is always loose, right? I'm always working, helping other people do stuff, but sometimes I'm not doing things myself. So alhamdulillah, you guys are encouraging me to do this stuff. And we think before we go to Hajj, before we do this, but honestly, me first, we should be thinking about these things all the time. We don't know when we're gonna pass away. We could pass away on the way home. Now, we all need to think about this seriously, because there really is no excuse. I'm busy, I'm this. This is just, again, like I said, it's a fard. So it's an obligation on all of us, and we need to take it as seriously as the other obligations that we have. Okay? So what is a living will? Living will is basically what is your will for when you are incapacitated and you are in an end-stage condition. Meaning that you're brain dead, or do you want to be on the feeding tube, or do you not? This is something, it's a personal decision, and it's a decision that, you should seek spiritual advice on, inshallah. I'm not going to get into that, but whatever decision it is, you should have it in writing.
You don't want to put your children or your spouse in the position
You don't-
to decide to take you up
Yes.
to whatever, because that's a very emotional.
It's an emotional decision, and the worst time for someone to make a decision is when they're under this kind of pressure. We're not, none of us, very few of us, except very few people, can have the mental wherewithal to make logical decisions in this, when they're under this kind of stress. Okay? When their father is ill, or their son is ill, and they're having to remove the feeding tube from that person. Okay? So what you decide with your spiritual advisor or should be what you put in writing so that the decision is not theirs. Don't leave that decision in their hands because you're putting them in a bad position. Okay? And then asset protection, we're not going to talk about that right now. This thing is also very important for married people. The way you own property, the names on the property in Florida, if you own it as husband and wife, or as a married couple, if you own it, the two names that are on that property, there's a certain default. If the married couple owns the property as tenancy as husband and wife, so me and my wife, we own a property, we both own the entire property, meaning I own 100%, my wife owns 100%. That's what entirety means. It doesn't mean I own 50, she owns 50. It means I own 100 and she owns 100. And that's something you need to understand before you purchase something. Because this is the default. Alright? And this is not something that was in classical law. This was something that was done later and very recently. Because in the West, until the 1800s somethings, women couldn't even own property. Right? And actually this entire system was created so that men could take their property after they died. Because there always had to be a man owning the property. So that's where this system came from. So it's important to understand that it's not 50-50 if you own it with your spouse. It's 100-100 unless it's death or divorce. And upon death, the person who survived owns the 100%. Upon divorce, it switches to whatever the court divides it as. Equitably, according to the court, right? Supposedly, equitably. Alright. So, that's something important to take into account. If you're buying new property, it's something you should discuss with your spouse. Because know that this is like now, when you know that you're doing this and that you have the option to own property separately or in a trust or in a company and as the entireties, then it becomes a conscious decision to own it by the entireties. Right? So I've seen people own all their property by the entireties, and when one spouse dies, the spouse's family says, no, he owned 50%. No, not according to the American law. So this is a conscious choice. When you're owning property, this is part of the discussion you need to have with your spouse and your attorneys. Very uncomfortable discussion. I've had very uncomfortable discussions with people. But I don't make the law. I mean, it is what it is.
I have a question.
Yes?
We're talking only about real property, not bank accounts.
All property. Any property in Florida. If it's joint by spouses, it's by the entireties. Assumed, unless otherwise stated on the document. So a joint bank account is assumed to be by the entireties.
The benefit is that if you're married,